relied upon as being legal advice for an individual legal situation, or implored for making a legal decision. You will not use any of this information for making a legal decision or performing a legal procedure, and is not a substitute for legal advice and or guidance by a licensed attorney. This private show and or documents are for academic informational purposes only, to be used at your own risk without liability to Christian Walters. By accessing or reviewing this show or using the documents therein, you understand with agreement that, with all rights reserved without prejudice, Christian Walters is not an attorney licensed to practice law in the state of Florida or any other state, and has not given legal advice or accepted fees for legal advice, provided no assistance, advising, or guidance of any kind for use by non-attorneys or pro se parties in the preparation or use of herein referenced, and has no interest in any use referenced therein, and is not a party to this or any action arising from, and is only acting in an authorized capacity as liaisons to communications between the parties. By reading and or using this information, you acknowledge and agree that you are not a client of Christian Walters. These documents and or show recordings are incomplete and void without this notice agreement being attached herein by reference, and a breach of this agreement. Upon breach of this agreement, the breaching party becomes liable for admiralty commercial damages of $100 million or more per stultification or impairment per Christian Walters' discretion. Thank you for your understanding.
I'd like to welcome everyone to this Tuesday, December 28th, 2010 edition of Money, Banking, and Trust by Moving Titles and Commerce. I'm your host, Christian Walters. Welcome to NTT as New Test Technology, and let's go open it up for Q&A.
Q&A session started.
Anybody has a question, press star 6 followed by 1 to get in the queue line. Raise your hand. Star 6 followed by 1. Star 6 followed by 1 to raise your hand. State your name, where you're from. Anybody have a question? Star 6 followed by 1. Question, anyone? Star 6 followed by 1. Darren, you're unmuted. Darren, you're unmuted.
Sorry about that. I forgot to unmute myself.
Okay.
It's not really a question, but I'm hoping that your wife will post to the website. I sent a bunch of videos that I found, some legal videos. It talks about how to perform in court, how to object to certain things, how to get discovery in, even to the point of deposition. It was on various topics. I thought they were very good, very informative. Found some videos on jurisdictionary that also talked about how to do research. So hopefully we get those to the website, and I think they're excellent tools. Just sent over a federal citing on discovery itself on different motions that can be used, and I think probably the federal court's probably going to be the best place to have our arguments heard in equity, even though they're really not arguments. Just because we want someone who really knows what they're doing that's going to be listening to this. So that was really it, and I think maybe if we can kind of go over, because like sometimes what I'm doing is that how we're forming everything in regards, even before we're getting into court, and then once we're in court, there is a process and procedure that we're even doing, is where I want to be sure that when we're creating, because we're the creators, we're the ones that are creating the indenture and the special orders, which is really, it's a private contract with the trustees. And we have to be sure that we're wording that properly, because that's going to be the document that's really holding their feet to the fire to show the breach and to show that we have not commingled onto the at-law side. And maybe if, just to be sure that we're going through everything properly and having it structured properly, because it's hard to, once we do this, because everybody's very busy and, on their own things, and is to have anybody review our documents. So really, we got to go by our own advice, our own guidance, to be sure that we're doing it right. Once we, get those indentures and special orders through the notary off to the trustee, we got to be sure that that document is pretty much rock solid and that we haven't really made any errors in there. And if we can maybe touch base on that, because that's really the ignition that starts the whole ball of wax rolling.
Right. Yeah. experts, law summaries comes in for a lot of the foundational stuff, and that's what it really comes back down to, is the foundational or the elementary stuff, the elements necessary to prove trust, which is really talking about the trust test.
Right.
You've got the trust test elements in there, which are the elements to prove trust, then you should pass the trust test, and if you pass the trust test, then you got ignition.
Right. But I just think that it's also very important, because I've even known, even in creating the indenture and the special orders, is because really what I'm doing, I'm formulating a contract, and it's going, because I'm the creator of it, and I got to be sure that my wording is pretty precise. And also, too, is that we want to use equity terms, and that was like something that we uncovered, I think it was like 2 weeks ago, was the term of rescission, which is the equity term more or less to extinguish the debt. And there were certain terms that we want to use, and then there's certain terms that we don't want to use that kind of show like a commingling. But you brought that up, that showed the rescission, that I think the judge was saying, well, it's presumed that it meant this, but really it doesn't mean that. It means this.
Yeah,
I forgot what
rescission versus cancellation and termination.
Right. So right there, I thought that was a big key, and thought, oh, okay. Well, I went back, on an indenture I'm creating and kind of redid the verbiage, because I thought, okay, well, that was paramount. I thought that was a paramount point that case showed in using the proper vocabulary.
Right. As a portal word, yeah.
Right.
Both sides.
Even though, let's say, for an example, let's say if we do error by chance and use a term that we're not supposed to use, or as an at-law term, now isn't the judge supposed to look through the form and just get really to the substance of the trust?
If you were in equity, yeah, if you were in camera and chambers.
Right, so regardless of even if we do maybe error, then it's still supposed to look through that.
True, yeah, it's supposed to go back to the substance, yeah.
Okay, right. You see, I just look at it. I look at it as though, well, how can my argument be actually not so much tested, but actually try to be shot down? Because, like, even myself, and I know there's a lot of other people out there, most of their experience has been on the at-law side.
Well,
normally,
the other day kind of hits the nail on the head there. I think it was you that said that, that we need to put these documents together as an appeal. In other words, what you really mean is we need to have a higher standard. And we want to go by that standard being the appellate decisions, the Supreme Court decisions. We want to put this stuff together for them because they're the ones that know, which is no less than using the foundational stuff that they're aware of.
And that's interesting, and that's why on last night's show I brought this up, and I was just, sometimes we got to think outside the box. We got to be creative in our thinking. Sometimes we got to be able to think on our feet.
Well, our standards as being lazy sovereigns are just that. Frivolous, lazy, and they don't accomplish anything because we don't know and don't understand all of it. We think we're the ones running the whole show. No, it's not. So you get the knowledge and the understanding by spending the time in the research. There is no fine wine until it's time. You thinking you're being a sovereign and not knowing and walking in there and saying, all I got to do is say this or say that, and that's it. It doesn't work that way there.
And that's what I find. A lot of people that I talk to is a lot of times what they're looking for silver bullets. Well, let me just file this, and hopefully all my problems will go away.
Everybody will take the Wygate, the silver bullet, quick fix because that's what they are. They're lazy.
Well, and that played that was like even
lack of responsibility, and that responsibility is you got to spend the time to know this stuff. King knows how to run his affairs.
Right. And as Mel Brooks said, it's good to be the king.
It sure is.
That's a great movie. But anyway, the point, and there was something, and it was just something that here just recently, and it was I was on another show, I was speaking on this other show, because we were talking about administrative remedies and different things, and there was a point that brought up that I haven't had time to really research it, But then I was looking at a case, and it's a case I want to throw something back at you. I don't know if you've ever read it. Did you ever read the Northern Pipeline Construction Company versus Marathon Pipeline Company? It was
I haven't.
It was a Supreme Court. Are you familiar with it?
No, I'm not. No.
No, but it talks about the legislatively created courts, where it talks about the power of the local administrative court, which is really the original jurisdiction of all matters, of what it's kind of referring to. Now, I got to read the case. I haven't read. I just pulled it up and I copied it to a doc. I'm gonna sit down. I'm gonna read it, because the thing is, that's why my question was last night. Can we bring in an equity matter in an administrative court? Especially because I'm thinking if they're saying the original jurisdiction on most matters come on the local level in an administrative matter, maybe that's the court to be in. But my question was that can that court hear an action in equity? Because if a court does not have the authority to hear it in equity, just like even bankruptcy, can't hear it, they're going to dismiss it for lack of subject matter jurisdiction. They can't hear it. They can't. It doesn't. It's not a matter of there's no adequate remedy in law. That's not even the question, because not even that argument could be heard because they don't have the jurisdiction to hear an action in equity. Do you see my point?
Yeah, because we're not throwing the switches to invoke equity, and it gets.
Yeah, but what if their hands are tied? Where they just saying, this court cannot hear anything in equity. We're strictly administrative. So in other words, we know that.
I don't think. Well, yeah, it's true in an administrative court, but we don't want to be in an administrative court. We want to be in that same courtroom, but under the other venue under equity.
Right. Okay. I guess
there's misconception that the two forms of law have been merged. They have not been merged. They are still separate and succinct. What has been merged is they're administered in one courtroom.
Right, that was the merged part, but the courts are still separate.
Yes, that's the Maxi case centers.
Right, exactly.
Hutchinson versus Maxi. That said explicitly, they have been merged into one courtroom, administered by one judge, but they are two succinct, separate venues. At law and equity. Right.
But I just wanted to throw, and what I'll do, and I'll do this off topic. I'm going to get a copy of the syllabus and the opinion of this case regarding it, because what it kind of like it to summarize, even though I haven't read it, so excuse me for kind of shooting off the hip here, was saying that really in most matters the original jurisdiction of the matter relies at the local county level, which is in an administrative court. But my question is this: that might be so, but the thing is, that might be just all on the at-law side. My question is, if we're bringing in an equity action, and if that's a court of original jurisdiction, but they cannot hear an equity action, then we know we're spinning our wheels. And what I'm saying, and the reason I'm getting to this point, is saying we want to be sure we're going into the right court, because why waste our time, our money, our efforts in going in the wrong court just to have to turn around to appeal it again?
Yeah, and then get shot down too.
Yeah, let's just be sure that we're aiming at the right target right off the bat, and let's not even go through that.
Well, that's what's surprising. That's how dumb people are, because we had one person that did exactly that. They went into a court and said, hey, blah, 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 and here this court wasn't even a court of equity. That should have been the first thing that you should have checked. But that's how dumb we are.
Right. It's just like a lot of it's just like some people they'll take an action, because you've had this argument for years, which I've disagreed.
That is almost like so basic that why wouldn't that be an automatic to make sure that you got a court of equity to go into? That's like a no-brainer. But that's the problem. We don't have any brains.
But you see, there's now yourself. For the longest time, there are these people that have believed, everything's an admiralty. And then what happens, they file a suit
But that's
and
where
claiming
it ends
the jurisdiction.
because we don't go by that stuff. We're here under different 180-degree flip-flop, and all that other stuff we counted as DC, and we're here in just for the private equitable trust.
I know, but I'm just using that as an example, even to illustrate the equity side. What I'm saying is people that, like, just for an example, they would bring in an action in admiralty into a federal court, and then the federal court would kick it for lack of subject matter jurisdiction. Why? Because they didn't have the jurisdiction to hear that argument. And it's the same thing. If the court we're going into cannot hear an action in equity, we know we're in the wrong court.
Right.
And that's my point. Is let's be sure we're in the right ball field. You're not going to bring your baseball glove to a football game.
Right. And isn't that kind of like a basic thing that you really shouldn't have to tell somebody about?
Duh. Yeah, but, you know, if you look at it, look at a lot of the fundamental errors that we make, even involving our paperwork, from rising to the, once you get a complaint, you got even like what we were trained even on the ad law side. You get a complaint, you got to answer it timely. You don't answer it timely, they're filing for summary judgment. Now you're behind the eight ball. Now you're trying to dismiss that summary judgment when you should have basically answered it to begin with.
Right.
You answer everything. It's the same thing as you get a letter from the IRS. You answer it specifically, but it's how you answer it.
My people are bound by fear for a lack of understanding. They're perishing.
Oh, boy.
They fear the court because they don't have any knowledge of what's going on. They don't know what their rights are. They don't know what they can do to defend themselves. So they figure it's better to bury my head in the sand and maybe this might go away.
Well, you know, I'll tell you, it's been so enlightening just in the last year, and you know what? It just amazes me is that, you know, just my own personal belief, God puts me with the right people. He really does.
What it says in the scripture,
and
it says, the watchman on the wall says, hey, I see the enemy. You got to pick up your sword and start fighting, people. If you don't, your blood's on your hands. It's your responsibility to start fighting. And you fight
right,
knowing the knowledge and understand
right.
that.
But you got to remember two words too. He said, "Fear not."
You don't have to fear because you know and you understand.
That's right. And you know, there's such a big. But the thing, I'm just saying, I'm really giving a
Free.
plug to NTT.
What? Free from fear.
Well, you know, the thing is I'm really giving a plug to NTT because even for the longest time, being on the DC side, I thought what a right was and never really realizing that was a statutory right, which was nothing more than a benefit or privilege, where on the equity side, I have an unalienable right that is free and void of any waiver, whether knowing or unknowing, and no one can take it from me because it's endowed by my Creator. That is a true right. Anything else is nothing more than a benefit or a privilege. If the government is giving you, calling it a right and giving you a right, that means they can take it away, and it's not a right, it's a benefit or a privilege.
Absolutely. Now, if everybody knew
and that's my story, and I'm sticking to it.
if more people knew that, that's the thing. But that's why we're here. We're trying to unlock your mind.
Right, and that's where, getting back to, I guess the original question was just in regards to the formation, because it's just like when we're getting started, it's the verbiage that we use in our documents, even from the UCCs and even the indenture and the special orders. I think that's key because that's really the beginning part of the battle, and we got to be sure that it's formatted correctly and properly and everything's there. And then, of course, then we move on because it's a step-to-step-to-step process. But once you understand the process, you know, it's just like if I could use it, and I'm not stereotyping, it's just like the Japanese, you know. They couldn't invent anything, but boy, I tell you what, you put something in front of them, they could reproduce it. And it's the same thing. Once we know the format and once we know the procedure of what we have to do, okay, and that's where, I mean, I really had to renew my mind, and I know I was driving a lot of the TAs crazy, and I you know, hey, thanks, guys, for being so patient with me, you know, because I know I could be a real stickler, especially when I think I'm right. Because that's my ex-girlfriend. But anyway, that's another subject. it's where we got to go in. It's creating those UCCs, special orders, and the indenture, sending it all through the trustee, through a notary, but it's signed by private people. Now you have it. Now you're waiting for the performance of the duty. It doesn't happen from the trustee. Now you got them in breach. Now you can bring your action into that open court to first declare the trust and to get a protective order so they can hear it in the private to prove that the trust exists and that the elements are all there to satisfy that and to show that a breach has occurred, and then moving for the declaratory judgment against the parties. Does that sound pretty much in a nutshell, in a minute nutshell?
Yeah. Well, what was that case that you were quoting before you mentioned?
It was
Thompson or
It was called Northern Pipeline Construction Company and versus Marathon Pipeline Company, and that was, I'll tell you exactly where it is because I got it pulled up. It's kind of a long case.
Why did you
I got to read.
Why did you mention that one? Is there something special about it?
Yeah, because it was something about original jurisdiction is because of the way that the courts are set up, not Article 3 courts if they're legislatively created, which also is relevant under the Bankruptcy Act of '78. But it's talking about a specific court. Which is the proper court, the proper court to hear a matter. And I haven't read the case, but this was something I spoke to. There's a guy on some of the legal groups. He's called The Inhabitant. He writes very sophisticated emails. Unfortunately, they don't come with subtitles. But we also discussed this the other night on the show, where they were trying to say, and I know Rod Class has been doing some research on this, where the primary jurisdiction, I've heard George Mason talk about this on administrative matters, is the original jurisdiction happens in the local level on the county level. Now that's why my brain is turning, and I'm thinking, well, if that's the fact, if that's true, and original jurisdiction where everything had occurred, because it's based where you're domiciled, I won't say reside, that's a trust term, is that if that's the case, then can a local court on an administrative basis, can they hear an action in equity? I'm just trying to think outside the box. I've got to do more research.
Here's something I would throw out as a caveat. Could it be that jurisdiction has been put into trust and it's not accessible today, only on the equity side?
Possibly, yes. Just like common law.
Yeah, because I think that's done with it. And it's not accessible unless you come through equity.
Right, but then here's my other point, because if those courts are established, and especially under the APA, like in Florida's Chapter 120, especially if our grievance is against a state agency or its agents, maybe that would be the proper place to bring a breach in, especially if you're dealing with a local agency, whether via through the state or what have you, that's maybe a satellite office through the state, but it's still tied up through a state agency, and maybe that is the proper court to address it, because under the APA, that act is created to hold them accountable, not us. Just like the Constitution. The Constitution's not made for the people. That is an instrument that is to be used against the government, so they don't get real big. That's what the purpose of it was. Now, all I'm trying to do is just think outside the box here, and I'm thinking because we're talking about, we know our action is going to be in equity, and what I'm looking at is, okay, well, we know probably the federal court is going to be our best option. We think that they pay a lot closer attention to the laws, and I would agree with that to most avail. But my question is now, if this argument has any validity to it, based on research, and like I said, I'm just kind of shooting off the hip, and I haven't really done the research, but if there is some validity to it, because remember, jurisdiction also pertains to where the event or where the redress or the incident occurred, the domicile incident, the area. So maybe there is a validity to it, and what I'm saying, I'm not knocking anything out of the box. I'm just saying maybe this could be a possibility where that even gives a stronger point to bring in our action in equity even on a local level without even going to the federal level. maybe. It's just a maybe, and I'm just shooting from the hip. But I want to read more about this, and I'll send you over a copy of it because I've read some different things on it, and I've heard the argument from different people, but I haven't done the research on it. So, but we want to talk about getting into the right court that can hear our action in equity. And we know we can take it on the federal level. We already know that. We could do that. Because we think that they pay more attention. But I'm saying, well, what if there is some validity to us as far as original jurisdiction at a local level in an administrative action?
Yeah, but
so,
I've got to put into trust also, and that's the problem, I think.
Right. Okay. So yeah, but in my thoughts was this. It was just like last night we were talking about different things. Well, let's not base it on assumption. Let's find out for sure.
Yeah, I think they put everything in the Republic that meant anything with substance, and that we keep on trying to bring into the at-law side. They put everything in the Republic in trust, and they made it accessible through the door of equity. And that's how they're keeping everything. The gatekeepers are keeping everybody out, and that gives them the total authority to administer through these administrative courts any way they want to, and that's the at-law side.
Because that's only a benefit or privilege, and they can grant it or take it away.
Yeah, yes, absolutely. But the key is getting into equity, like you said. But I think here it's like we're trying to reverse, and here that lower court, the county courts and things, which were set up to be the true seat of government, has been put into trust, and now it's held in trust and can't be commingled. And the only way you're going to get it is through equity, and there's that big question again. Where's the equity door? Because that's what's being hidden. And it's being hidden by an at-law process and procedure of a specific domino path. And if you don't have it exactly right, you can't get past the doorway.
Sure, I agree with that. But the argument was, or the points that certain parties were making, they were saying, like the circuit court, the state court, and even the federal court, these were set up actually through the Bar Association, through the legislative branch, where the true original jurisdiction of any matter, whether it's foreclosure, re-grievance, or everything, is actually...
I think it's really the P game, the shuffle, the Kansas City shuffle. You're being taught to look over here on the left, but where you need to be looking is over on the right. Have you ever studied anything about concurrent, exclusive, and auxiliary jurisdiction?
I've read briefly on those topics, briefly. But
when we were
more on
the trusts and we're discussing some of the older books in that, maybe on the Wednesday call, and I remember reading it before under the trust book when we went over that. But it talks in there about, the exclusive jurisdiction is trust, for one thing, in equity. And the other jurisdiction is concurrent, and the last one is auxiliary. And I think that these are really I've been doing some further research into it, and I just wondered if anybody else has also, because those three divisions of equity, which are exclusive, concurrent, and auxiliary, I think are the doorways or the keys that need to be put in a certain sequence. Because auxiliary is nothing more than a counterclaim. Concurrent is you've got the at-law side running simultaneously with the equity side. And exclusive is you have a trust. Exclusive jurisdiction is a trust, a private trust. That's the only place a private trust should be, because it is exclusively administered under equity.
And it sounds just like even in the adjective that describes jurisdiction. You have exclusive, which means it is exclusive. Concurrent is that it continues, and then auxiliary is just like an add-on.
So when you do a counterclaim, which is your bill in equity, what you're doing is you're switching the concurrent to auxiliary. And then if you're coming at them with a trust, you're taking the exclusive and moving it in also into auxiliary. And what you've done is you've merged all three of them. You've done a merger, and you never knew it. It's this the key that you need to understand it by. You need to take 3 steps back and look at it from a different perspective. as a
you know how you just describing that. You know how I was thinking of it in my mind is the same thing like a football team. You have your guards on the front line. They're exclusive. They're right there, and your running back is your auxiliary. You're trying to get through to the other side. You know, that was just a brief scenario.
Well, then in a way, that's kind of a way of looking at it. It might be even halfway right. So because you're using the counterclaim as being auxiliary to run in to get into equity, which is your bill in equity. The counterclaim,
right.
Which is auxiliary.
Right. Mm-hmm. Yeah, because hence the word auxiliary. Anything that is an auxiliary is just an add-on from the main. It's like if you have a main complex, you can also have an auxiliary, which is just a runoff from the main.
If we look under Black's Law 8th under jurisdiction, let's see if I can find it quick. Okay, jurisdiction. Auxiliary. It says a court's jurisdiction to adjudicate claims and proceedings related to a claim that is properly before the court. For example, if plaintiff brings a lawsuit in federal court based on a federal question, such as a claim under Title 7, the defendant may assert a counterclaim over which the court would not otherwise have jurisdiction, such as a state law claim of stealing company property. The concept of auxiliary jurisdiction has now been codified, what hasn't, along with the concept of penitent jurisdiction and with the supplemental jurisdiction status. That's 28 U.S.C.A. Section 1367. It says see supplemental jurisdiction, compare it with pettit jurisdiction, and also it talks about CJS, courts, and number 66, and equity, section 9, 80, and 87.
Okay.
Now, you've got exclusive jurisdiction. Exclusive jurisdiction, a court's power to adjudicate an action or class of actions to the exclusion of all other courts. Exclusion of all other courts. That's trust. So the federal district courts have exclusive jurisdiction over actions brought under the Securities Exchange Act. Compare concurrent jurisdiction, and then it's under cases and courts, and then also equity again, in federal courts and CJS courts, and also equity again under 1951 through 53.
Well,
very convenient, and equity is in all of these. Now, the last one, concurrent. Concurrent jurisdiction that might be exercised simultaneously by more than one court over the same subject matter and within the same territory. A litigant having the right to choose the court in which to file the action. Now, that's the age of majority. That's power. That's your power right there.
And that's also invoking.
Yes.
That's where you have to invoke it. You have to invoke it to create the power. It's like speak the word. You have to invoke it, but even what you were saying earlier, the court has to have the jurisdiction to hear it, and then that was my point before. We have to be sure that they have the authority to hear it.
Exercisable in equity in order to get into equity. So there's where the exclusive comes in because you got to breach trust. That's automatic. That's exclusive.
See, but my question is what kind of equity are they referring to, though?
Okay.
Statutory equity?
This is plainly probably, statutory equity, but the mirror image on the other side is probably the look-alike or the equivalent.
Right.
So let me finish up cases. It's talked about admiralty, courts, federal courts, and then under CJS, courts, and then it goes to the number 2 definition, jurisdiction shared by 2 or more states, especially over the physical boundaries such as rivers or other bodies of water between them, and also termed coordinate jurisdiction, overlapping jurisdiction, and compare exclusive jurisdiction. Then it says in the fine print, it says, in several cases, 2 states divided by a river exercise concurrent jurisdiction over the river, no matter where the interstate body may be, and in some cases by ordinance of 1787 by organizing territories northwest of the Ohio River, and in some case by acts of Congress organizing territories or admitting states, in some cases by agreement between the states concerned. And that was out of the Treatise on Conflicts of Law, 1935. But there's the three jurisdictions,
and there goes back to territory. It was talking about territory. It was talking about subject matter, I do believe, when it was talking about the 1787 of what they can hear and what they can't.
It's kind of like a treasure game. We're treasure hunting, and we're doing, what's that movie, National Treasure?
Right.
And it's the keys that you have to have in these fancy-looking doors that you don't even think they're locks, that the key is, and you got to put it in the right way and have the right thing, and before the door opens up. And the whole room changes before your eyes into a treasure room when you thought you were looking at nothing but empty space. And I think that's what the courtroom does. It changes before your eyes where this judge, all of a sudden he's not a judge any longer, he's under the conscience of the court.
Now he's a chancellor.
Yes. And everything seems to morph into something else, and you're treated differently.
The question is when is he really the chancellor? Is he a chancellor even when in the public side, if addressed as chancellor, or would that be a commingle? Or do you address him as chancellor when in chambers only?
Well, I don't know. Maybe we just haven't thrown the right switch for him to put on, the right, or take off the face mask, let's put it that way, and act like a real man with a conscience.
Right, because if you're going in with an action in equity, but first we got to go in through the incorrect door to get to the auxiliary door.
Yeah, we got to put the face on, come in and act a certain way, and then we take the mask off and we act like real people.
Well, the thing is, if we're on the outlaw side, he's a judge. But but we're in the equity side, then he's a chancellor.
Chancellor, right?
He's got a different hat on. It's just like where the courts have been. The courts are still separate, but they're in one building, and it's just like he's the same person, but he has different hats.
Yeah, but then it involves the concurrent, exclusive, and auxiliary in the right combination, and the switch is invoked in the proper sequence according to the bill in equity in order for that to happen.
Yeah, so I'm just curious, is when do we actually address him as chancellor? Should we do that right off the bat in the at-law side because we have a pending action in equity to show breach?
Yeah, you address it as your letter rogatory as chancellor because that would be the private side.
Right. Okay. I'm just trying to think outside the box. Is when it happens. When do we flip the switch?
Well, I don't think we're quite there yet. So we've had some indications that the judges are trying to, because they see what you're trying to do and they understand, and they're really trying to help you out. And I can see it like they're trying to, but yet their hands are tied, and they can't really spell it out for you black and white, because you got to do it yourself. And it's like, okay, I'd like to see you.
But they have to be. They're supposedly fair and impartial.
Yeah, right. But now, in the same sense, they've got the power to say, hey, this isn't right. We should be doing this. But hey, they got their retirement to worry about.
Right.
And a nice, cushy life.
They have a vested interest.
Yeah. It all comes back down.
Yes.
We're the ones that's supposed to know, because we're the ones that got to be able to force their actions to be doing the equitable thing.
If we're going to be sovereign, you better act sovereign.
Well, I'm saying that as a sovereign, we know how to make those other people do what is according to equity. Right.
And that's by invoking what law is going to be heard in that.
Yeah, so we're on a national treasure hunt. So we've got enough clues. Now all we got to do is put it in the right sequence.
I think it was.
It's transform itself into equity.
What? Now wasn't that in the Chisholm v. Georgia case? It was like 1827, and I think didn't the judge, even though there was a long drawn out part where the one judge was just rambling, but wasn't it emphasized as though he was saying that God is sovereign, man is semi-sovereign, the state is semi-sovereign, and the employees of that state are semi-sovereign. I think he was kind of making an emphasis on that because the sovereignty lied in the people.
Well, that's where it truly relies, yeah.
It really does. It really does. And that's where, like, even what that one senator said, the problem is we allowed a trust to come in when there was a void of the law because of the collapse of the monetary system back in 1933.
Yeah.
It was our own fault. We allowed it to happen.
We have no knowledge of or understanding of what ramifications and how powerful that was in destroying everything that we know and hold true to our close to our hearts. But you know, it didn't destroy it; it just hid it. It's hidden. It's hidden in trust.
Well, you know, it's similar to like one man's sin condemned all mankind.
Yes, yeah.
You know, but there was a redemption.
I'll say the counter to that. Yeah, one man's death fixed it all back.
Yeah, so it's interesting. It's interesting. That's a good analogy when you think about that movie National Treasure, because you know things just aren't what they seem to be, and really you have to dig deeper and just kind of know, and you got to have kind of like the map to know what to do. So that's why even with the NTT process, we still have to know the correct steps of what we're looking for is a relief to a specific issue and controversy. Now, so how do we do it? We create our UCCs, we create our special order and our indenture and the special orders. We go through that process, and then once we have the breach, now we have our action to be heard in the court of equity. And then what do we do to get to create an action in equity? Well, we know we got to have a bill in equity. We have to have our petitions for discovery. You know, it's a step-to-step process. It really is, and that's why we got to be so keen on the steps. We got to be sure we have the steps right. We have to be sure we're in the right court. But I think once we get the process down, and then really formulate and know how to create our own documents, whether they're a court pleading or whether they're a special order and indenture, that's what we got to be. That's what we got to be sure on. The only thing that gets kind of, I guess, into the unknown is when you're creating the indenture of knowing what to do and what not to do. Because like they were saying on I think it was Monday's show, was there was some guy that he actually made the indenture a part of the trust res. And, you know, sometimes it's not knowing exactly what to do, but really what not to do. You know, so it's kind of like having a kind of a map to know, well, here's the sequence of how we have to do. Just like the way Dr. Graves spells it out in Jurisdictionary. He shows the process. He does the chart of, well, here it is. It's a complaint, and you're going to have the flurry of motions. And when you formulate your complaint, you got causes of action. You have to have the elements of the causes of action. There's a map. There's a guide to show you what to do, what not to do.
Well, that's what we're working on, but we need more people that are up to speed and understand, and we just don't have the manpower, let's put it that way, to do everything.
I agree.
We've got the textbooks, we've got the audios, we've got a wealth of knowledge that's already been gone through and sifted through, and it really comes back down to the basic elements, the foundation, the elementals, the elementary things that people have to really have a strong grasp of those things. Otherwise, your building's going to collapse. You're building your thing on shifting sand without a firm foundation.
And
all
you know, it was
foundation.
You know, it was funny. It was Sunday. I was watching a football game, and they were showing the old Green Bay Packers and Vince Lombardi. And what he was saying was that they didn't have any superstars on their team, but what they did was that they were so regimented and they were so good at their fundamentals. That's what made them a world champion, because they knew their fundamentals and they knew them like the back of their hand. And that's what made them such a great team. It wasn't that they were superstars or they were, you know, super fast or super bright or, you know, super intelligent, but they had the fundamentals down and they knew how to execute the fundamentals.
Yeah, they knew how to execute a defense. They knew how to execute an offense.
Right. But it was because the fundamentals were laid out to a T.
Yeah.
Okay, that was really the only thing I had a question on.
There are no shortcuts to building a skyscraper. You got to drive the iron beams down to the bedrock. You got to build a strong foundation, or else the building will never stand.
That's true.
You can't build roof down. You got to come from the ground up.
Yep.
And the amount of time you spend on the foundation, increasing the size and the strength of the foundation is going to be the determining factor of how tall your building will be.
Or as they say in the music business, you better be sharp, or else you'll, or you better, what is it? You better, you
little
better
dogs can't whiz tall weeds like big dogs can. There is no fine wine before the time. Rome wasn't built overnight. I don't care what analogy you want to put it to, it comes down to you got to put the time in. You got to do the study. You got to do the research, and nobody can do it but you yourself.
Because you got to know your own rights.
Yes. Nobody else can enforce them for you.
Yeah, and that's why equity can only be performed in persona.
Yeah, yeah. But we don't have to know 63 million statutes and codes. All we got to know is less than 20 maxims.
Yep.
Understand them like the back of your hand. And when the judge says something, you just come back with a maxim.
Yep, I agree. Okay, that's all I got, Christian.
All right, so we've got a few others in line, so if anybody else have a question, press star 6 followed by 1. Star 6 followed by 1. Who's next?
Hello.
Hello. Who's this?
Hi. Is it me? It's Winnie.
Hi, Winnie. Hi.
Hi, hello. Can you hear me?
Yes, you're on the air.
Okay, right. I have some problem. Let me see. I don't know where to start. Right. I can start from the bank. Instruct the solicitor, their solicitor to sue me for the overdraft of just over £2,000, and I counterclaim, and I express trust against the solicitors, the law firm's directors, and also the bank's CEO. And the law firm, they filed with the court all the trust paper that I sent them. It's supposed to be for their eyes only, and they filed with the court the trust declaration agreement and also the notices that I put on the website. So, and also I also send them the debt collectors disclosure statements and requests for emissions, and also previously noticed that they're not to notify them not to pass my information to any third party. But they say they are not going to respond to my debt collectors disclosure statement and request for emissions. And also, I don't know what step to move from now. Can you give me some
Well, if they're
help?
not going to respond, if they didn't respond, then I would certify that they didn't respond. Well, over in England, they're different.
I send them
To certify that. Your notary certifies a dishonor that they wouldn't validate the debt.
Yeah.
Now they're starting to create an unclean hands situation here, which violates the maxim. They're coming into equity, saying they want equity to do certain things, and they're not doing equity themselves.
No, they're not doing equity. They're not doing equity. They say this is the relationship is. Let me see what it says. It's creditor and debtor relationship.
Yeah, but now they're filing all your private nature documents. So are you objecting and putting an encounter motion and asking for the court to quash those documents and seal them up?
Oh, yeah. This is what they also tell the court to strike out my counterclaim, and
well, I'd be going after striking their documents they put in that were my private documents and making them public, or at least asking the court to seal them.
What does that mean? What does that mean? Make them public?
Yeah, because I have to make some kind of manifestation of my intent to keep them private. So I got to put some kind of counter motion in there or some kind of objection and try to keep them private. Otherwise, I'm going to waive the private nature of them by allowing them to put it into public.
They already put it in the public, my trust declaration agreement.
You need to do some kind of positive action to try to reverse that, which demonstrates your intent of the private nature of the documents. Keep them private.
Okay, so I have to tell them. I don't really understand.
You have to put a motion in the court.
Mm-hmm.
Motion.
Okay, motion with the court.
Yes, that's what I would do. I would put in a counter motion, an objection, and a motion to quash those documents, remove them, or get them sealed up, so that because it's revealing the private nature of the documents, I don't want that in there in open court. I want that reversed.
Oh, okay, right.
Now, I was reading in some older books that in the UK there is a special court of equity. It's not like here in the States that one court is administering equity. Now, I would check to see whether or not you're in the right court. Because I think there's an exclusive court, the Court of Chancery in England, and that's the only place where equity is administered in there.
Yeah, my previous case, they transferred my case to the Court of Central London of Justice Centre, which is not Court of Chancery.
Okay, you need to bring a action in the Court of Chancery.
But this court, it said the Chancery list at Central London, it now comprises instances for 3 sources. And it says like Chancery Division of High Court. Second is the cases transferred from the other court.
Yeah, because I think you are not in a court of equity over there. You have to go to a specific court, and that's the Court of Chancery, I believe, and that's how you get into equity over there. If you're not in the Court of Chancery, there's no hope that you're going to get any kind of equitable relief. Because where you're at, law side of the court, and you got to get in. You got to come at them with an independent action, your counterclaim, your bill in equity in the Court of Chancery.
All right. I don't know how to do it yet, but I have to ask around and find out how to transfer it to Court of Chancery.
It's different over there than here. Here we have one court, one judge administering 2 different realms, at law and equity. Over there, you've got a separate court that is specific for equity and equity alone, Court of Chancery.
Yeah, okay.
If you're not in a Court of Chancery, not in equity.
Yeah, I know there is one in Extreme in Central London.
And once you get into Court of Equity with your bill in equity, then you ask the Chancellor to put a stay on the at-law side over in the other court until this one's heard.
I don't really know how to do it yet.
Okay, you need to get somebody with some more UK knowledge over there that's got NTT knowledge also.
Yeah. Okay. Right. So for this case, if I apply for motion to squash, to court, to what's it called? Motion to
strike
the case, is that mean?
Motion to strike those documents that they put in.
Okay. To strike those documents they put in. Okay.
It may be different.
Do I have to mention that those?
It may be different.
Do I have to mention that those documents? Sorry.
It may be a different motion over there.
Oh, right. Do I have to mention that those documents are supposed to be kept in private?
Yes, I object. You're making public the private nature of my documents. And if I don't object and put in a motion to strike those or seal them up, I'm going to waive the nature of them, and they're made public.
Yeah, but my document says very clear it is for your eyes only, but the person, the director, the solicitor...
Well, there's plenty of signs out there on the roads that say do not trespass, but many people cross over the signs and they don't ignore the signs, so they break the law. So what happens when they break the law? Somebody's got to object and got to go do something about it. That's what you got to do. Can't just say, oh, they made my private documents public, they filed them in there. No, you got to do something. You got to do some kind of positive action against that. You know, I object, I put in some kind of motion to strike or something that seals the record up and gets it out of there. And that action is the manifestation of my intent. And what's my intent? That these are private. If you don't have the action, because the only thing they can see is a record of that action. That's what demonstrates your intent.
Yeah.
and I'll get in the right court.
Okay.
The more you hang around the at-law side, the longer it is, the easier it's going to be for them to defeat you. The at-law side is not where I want to be playing around. Want the court of chancery.
Can they refuse me?
And what?
Can they refuse my request, my application? Can they refuse not to transfer to court of chancery?
It's an action that you're coming at them with a bill in equity. You're coming at them with a claim. And your claim would be, this is a trust, it's a breach of trust. Two simultaneous actions running in two different courts, concurrent. In your case, it's two separate courts, two separate venues, two separate courthouses. Look at some of those old books, some of those old pre-1933 books in equity, books on trust. Look in some of those and see about breach of trust, how to enforce them. And I'm sure in the library they've got some more modern ones there that would back up under your law venue, because it's different than here in the States. Anything else? Still there? Can you hear me, Winnie? You there? Hello? Hello? I'm on? Still? Okay, maybe we lost Winnie. Okay, Doyle, you're up next. You're unmuted.
Hello, Christian.
Hi, Doyle. Hi. It's Don, right?
Yes. I wanted to discuss with you, or talk a little bit about you, or with you about ecclesiastical trust. Are you familiar with the Sedike v. Trust?
Not a whole lot. The Sedike v. I started on that. I did a definition search of it, pulled it out, and I think I stopped right at the definition because I could see right there the definition. I forget what it was now.
Well, is it a possibility that these trusts, the Sedike v. Trust, are what's hindering us from a remedy?
No, I really... In what respect?
Well, when you're born, you are issued a birth certificate, right?
Mm-hmm.
Okay, that certificate is a indication that you are a beneficiary of the trust, which is set up at that point, right?
Right.
That's a Sedike v. Trust, which means trust for life. The next one that you're involved in is your baptism. You get a baptismal certificate, okay? That is a claim. The first one is the claim on your body, and the baptism certificate is the claim on your soul. So now, if someone else has claim on your soul and the claim on your body, in their eyes, you're considered a dead piece of meat, and as such, you have no standing. Would that not be correct?
Yeah, but I think it's more of a debtor-creditor point of view. Rather than from a trust respect, I can merge.
Would you proceed to do the same merger on the Sedike v. Trust as you would any other trust, like return the birth certificate and return the baptismal certificate and proceed forward, terminating those trusts?
Yeah, I could do a merger on those as well.
Well, it is a point of view of another person who was talking about trust, that this is the situation, and that everything is sort of locked into these trusts that we don't know anything about except the fact that we've been issued a certificate, and that until you get that
certificate is nothing more than a certificate because you never expressed it to be anything other than that.
Yeah, I suppose they're implied trusts, aren't they?
Well, they could be implied, but yeah. It's whatever it is you want to choose it to be, you've authorized it to be as it's acting now. Through your mother's, it just turns out to be a birth certificate, because if it is a trust, you need to express it as a trust, and you haven't done that.
But in their eyes, do they, the powers that be or whoever's in control of that, would they not As far as they're concerned, you're in a trust, whether you know it or not.
Yeah, it doesn't. On the private side, you could be in a trust and not know it. Yeah.
Mm-hmm. So if that is their view, and they're viewing you as a dead piece of meat, piece of property with no standing, then you can declare all you want that you're a grantor or whatever you want to declare, and until you've rebutted their presumption that you're a dead piece of meat, do you have standing?
That's where do you get the authority? How do you get the authority? That's the thing.
Get the authority for what? You mean for declaring the fact that you're a live body and you have blood flowing through it and your body's warm?
Yeah, because if they consider you to be the dead straw man, whether it's through this Sedekey V or whatnot, then how do I get rid of it? And it still comes back down to trust principle, merging the titles and extinguishing what was done.
Mm-hmm. So would that not possibly be a hindering or stumbling block to this concept of getting remedy if they're seeing you as a dead piece of meat or a dead entity?
Well, I think Key V is more for representation as the straw man trust as being a dead entity, just like you said.
Well, they're claiming rights to your soul. That's what salvation is all about.
Yeah, but ecclesiastical law is nothing more than really like statutes and codes.
Yeah.
It really comes down to equity. That definition of equity.
We stumbled onto some of this information.
Well, the Sedekey V stuff is more popular in outside the country.
Oh, yeah. Is that not what's being used with the ecclesiastical trust? The
What if they were both the same thing? But
yeah.
one side's just calling it the Sedekey V, and the other one's calling it Sedekey Trust.
So one and the same?
Quite possibly. The Sedekey V applies more towards estates. Now, is your estate a trust? That's the question. Have you declared it to be a trust?
Right.
An estate is not a trust. A trust can be an estate.
Well, it was just some food for thought, or interesting anyway. If you think of the concept of these people who are in control taking the possession of your soul, which is the life force of the body, that would make sense that they could say that, well, because we own your soul, you don't. You are basically just another animal.
Well, what was your intent? What was your intent?
I would imagine in that the child has no intent, at least none implied, or maybe it's implied, but none in his intent. He's not asked what his intent is. When he's grabbed by the nape of the neck and put his foot in an ink blot and stamped it onto the paper, his intent is not a part of the question, is it?
Well, because he's being represented on behalf of the mother, and she ought
when the mother
to be done.
Certificate, is she not signing over ownership?
Well, that could be the implied contract, yeah, or the implied trust. Here all along, it's being expressed publicly as a birth certificate, and that's all it is in the public, because you never expressed it to be anything other in the public other than that. But yet it's operating on the private as a trust. And really, this Sedekey V is talking about a life estate, but the question is the estate a trust? And then if it is trust, we got the same problem. Has it been expressed into the public as to be a trust? Really, I think these we're talking about the same thing, really. Whether it's called Sedekey Trust or Sedekey V, it's all the same thing. So
right. So technically, one could
the core is trust, but on one side of the sphere of the ball, from an ecclesiastical point of view, it's a Sedekey V. On the other side of the ball, from another point of view, it's called a Sedekey Trust. But the core is being viewed two different ways, but that the core is still the same thing. It hasn't changed. It's still a trust.
Right. Yep.
So no matter what you want to call it, still you can merge it and extinguish it, or you can merge and extinguish the debt with it and terminate the trust if you wanted.
So is the individual who has the birth certificate and the baptismal certificate, who's in control?
Well, under a general deposit, they are. because you never requested to be a trust to be special. So we got the same problem as what we were talking about from the beginning under NTT.
So with that being said, is it possible that you don't have standing until that's taken care of or corrected?
Well, if the core is still the same thing, a trust, it doesn't make any difference from what point I'm on the surface and coming at it at. I'm still attacking it as a trust. And if you did it one way under the city key V, it accomplishes the same thing as if I'd done it through the Cesta K trust, because it's really the same thing. It's the core, it's the substance, it's the center, it's the no matter which way I look at it from whatever point of view, whichever position I'm on this sphere, the center core hasn't changed.
Right.
No matter whether I react to it from that point, doesn't change my position, but or rather doesn't change the center core at all, because I can do the same thing from any position on the outside of the surface and still achieve the same effect. So whether I merged it from a SETI key V point of view or I merged it from a Cesta K trust point of view, we're still talking about the same thing and both achieve the same effect.
Yeah. Okay. Well, are we any closer to getting this paperwork set up so that this can take place where you terminate these implied trust, if you will?
Hopefully in January we can release the documents.
Will be. Well, that's what I wanted to discuss with you. It was something we've been rolling around.
Well, I think we're, instead of straddling the fence and winding up sitting in the middle, just kind of like not get off track and stick with the same thing.
Yeah.
Has there been any new developments in your...
No. We put in a motion yesterday to dismiss the bankruptcy. We decided that that's not going to be of any benefit. I won't help us any. The adversarial claim is proceeding forward.
That stays?
Yeah.
Yeah, because that's not acting under bankruptcy. That's acting on the federal side of the court.
And we were kind of suspecting maybe that's where we will be able to enter the equitable side through that case.
Right. Because the bankruptcy is kind of like a smokescreen, which could get you into the federal side of the court, and because they're two different things.
Now, do you think there's a possibility they would dismiss the adversarial claim if the bankruptcy case is dismissed?
Well, that might be a possibility. I don't know. I have to check with somebody else.
Yeah.
That might be so because that adversarial case grew out of the bankruptcy. So I don't know. If you close down the bankruptcy, that might close down the adversarial case.
So it might be necessary to file a new case?
Yeah, you could always go into state, say, or federal again. I think, if it was me personally, I think I'd remain the bankruptcy open and try to come through the adversarial part and get into the equity through the federal side.
Well, they converted to a Chapter 7, so now they're wanting to proceed with a liquidation process. We have not succeeded in having any of the at-law stuff halted until the equitable claims are adjudicated, and they're moving forward as though there is no such thing as equity.
Right. So there is no such thing as equity on that at-law side.
Yeah, in bankruptcy.
Right.
And we kind of agree with Darren that there's no equity in bankruptcy, not the kind of equity we're looking for.
Yeah, well, I always knew that, but there's the federal side to the bankruptcy through this adversarial action. That's through federal court, and in there, there is equity there.
Well, if the adversarial claim can be adjudicated in equity, will that not take care of everything that was associated with the bankruptcy? Because that's the whole idea of the adversarial claim, is that the trustee received the indenture and has repudiated, and the indenture was for the trustee to extinguish all debt related to the bankruptcy.
Yes, there's something that's just like there's a piece of the puzzle missing. And that's why it's not working. And I can't say exactly something that wasn't done. you're like close. You're skirting around the doorway, and I think the judge is reacting, favorably to certain things, but then he has to go back and do because the at-law side was still in play, and equity has not been truly invoked.
Yep.
From what you've told me, I can see where the judge is in certain positions where he's trying to help you, but then in the other way, his hands are still tied.
Well, at the last hearing, he lifted the stay, and the next day they came and closed the business. So
lifted the stay.
Would that not be an equitable claim for damages, or not damages, but for breach? Well, not breach of trust. Be that too.
You could get into equity.
Beg your pardon?
Yes, if you could get into equity.
So they are depriving him of his pursuit of happiness, are they not?
Yeah, the trustee was supposed to pay the bill so that the business could stay open, and the trustee hasn't done that. So the trustee's in a breach, but then you've got to get into court of equity and force the breach.
Yeah. Well, now, you can't ask for damages in equity, so what are they going to do about the closing of the business and all of that that's associated with that loss?
Well, you want the performance to pay the bill, and then the grace of the court should be that they're going to make you whole and anything else that you may have lost. But you don't ask for that. That comes out of the court. So I wouldn't ask for damages, although you may get damages. The court may award you damages. But, as this model progresses and becomes to take more definite shape and the picture puzzle becomes more clear, when we first started this, there's been some fundamental mistakes that I think have been made, and maybe some fatal ones. And highlights of what I got on this so far is the other day I was thinking, the bill in equity, which is the counterclaim, is really in personam and not in rem. And I think that's a mistake. We're not coming at it in personam with a subpoena.
So, you mean that whenever you do the bill in equity, you send it to the CEO with a subpoena?
Yes. On the first hearing, he's got to be a subpoena as well as the summons, because you got the summons is for the fiction of the corporations, and the subpoena is for the real live man.
Okay. Now, with that having been said, can we back up and correct?
Yeah, you can. A bill in equity is in personam, and
okay, so
not in rem. In rem would at law, and in personam's in equity.
Right.
And then the pleading special matters. It has to be stating that you're pleading special matters. And then under the pleading special matters, which was something we've mentioned, but I kind of forgot about it, which I think might be a fatal mistake, was under the pleading special matters, it must be in a negative averment.
In the form of negative averment?
Yes.
Okay. So now, if we've already got the bill in equity into the court, but haven't done the summoned the body of the live body, should that be the next thing done?
Well, it would be like a subpoena for the live man to appear with the documentation, duces tecum.
And that would be to the next hearing?
Yeah, into a hearing. And then everything that's being pled in the bill in equity must be in a negative averment, because that's the pleading special matters, and that's the breach of trust.
Okay. So it sounds like that this may be messed up already.
Yeah, then probably the motion to dismiss, which was the concurrent, dismiss the at-law side for lack of equity, and the ancillary suit, which would be the counterclaim. And that would be the better equity or the superior equity then.
Yeah. So it's
and then you ask, last one is you got to ask for equitable relief.
Yeah.
You got to ask for an accounting or tracing or receivership, and you got to ask for the performance of the breach of the trust. Was there any equitable relief asked for performance of the breach of the trust?
Well, in our bill of inequity, yes.
Okay, and was there a declaratory relief hearing set that's where your in personam is going to subpoena in the real live body for a proof of the validity of the trust?
We did that for the bankruptcy, but not for the adversarial claim. So we need to also do a declaratory.
It looks like you forgot that bankruptcy is not equitable, and the adversarial claim in the federal court is. So if you applied all this stuff in the bankruptcy, it should have been taken into the adversarial federal court and put in through there. So I would probably replead everything in this adversarial court. I think that's what the judge was saying before. Didn't he want you to put in an amended complaint because something was unclear? He asked for a bill of particular?
Uh-huh. And he said he wanted I think it was a more definite statement.
Yeah, that's a bill of particular.
So would that be put into the adversarial claim?
Yeah, either amended complaint or a brand new bill in equity. Because you might have put in a bill in equity to start out on the bankruptcy side, but and maybe that's why he asked you for a bill in particular.
Well, we did put in it.
Did he ask you from a bankruptcy point of view or from a federal point of view?
I think it was the bankruptcy hearing, so and he didn't distinguish for
Maybe that's what he meant. And didn't he say motion to dismiss something? The 13 to the 11, or to the 7.
Yeah, they did a motion for conversion. That came sua sponte.
Well, I think what I would do is I would come back in with the adversarial claim, come back in with a bill in equity there, whether you want to call it amended bill in equity or whatever, and then set it up for the in personam. Ask for the declaratory relief hearing with a subpoena ducis tecum. Make sure that bill in equity's got the pleading the special matters and negative averments on the breach of the trust. And I'd also ask for an accounting and a tracing, and that a constructive trust be placed over top of everything, the assets, and a receiver be appointed to trace the funds. I'd start going after the proceeds therefrom, and make it look apparent that you want to uncover the assets generated from your signatures, and I don't think they want to see that.
Yeah, they may run the other direction.
Then I go back in with another stay and injunction to freeze the at-law side that they're doing. I think you're so close to getting in, it's just that, it's crossing the fine line, crossing over the mirror, getting in the other side, and you're right there up against it, but you're not there yet.
Haven't found that point where we can slide through.
Right now, I wouldn't dismiss this bankruptcy case. I think because it probably all you could check if we dismissed it, if it still had the one adversarial claim, if it went on, okay. But I think I would use this adversarial claim, this federal part of the court, to get into equity, and I would try again everything that I've done, but redo it all.
Okay. We can do that. We'll hear more about a in-camera hearing.
Yeah, basically what we're doing is we're reviving the equity docket. Now, I don't know if the equity docket still exists. It almost has to, but we're reviving it.
Right. That may be what they're...
When I filed this in equity, I would ask them to revive the equity docket and place this on the equity docket.
Would that be done in the form of a motion?
Well, when you file the bill in equity into the clerk of the court, the clerk is the keeper of the dockets. There's got to be an equity docket and an at-law docket. Everything is being generally deposited on the at-law docket automatically by default, because nobody's saying, "Hey, put this on the equity docket."
Right. And because you didn't specify, they just go ahead and do general.
I think so. Now, that was true, I know, up until 1954, that there were exactly two separate dockets. Now, after 54, I don't know whether they've tried to hide that equity docket.
Well, now, that's interesting because the judge, in his dissertation when he gave rendered his verdict, he went into this diatribe about how the courts had been merged in 1954, which was absolutely contrary to everything that article said about the courts and the fact that they had merged them, but they were still separate.
Mm-hmm. Well, that's Hutchison. Maxey Center case says And that was like, what's the year?
88.
What was the year?
1988.
88. Well, if it's still an 88 case, then I'd say that's pretty recent.
Uh-huh. And there was no change in the Constitution that I've been made aware of.
Yeah, it's just that it's been merged into one courthouse or under one judge, but there are two separate venues, two separate dockets, equity and at law.
Yep. Well, you can't get up and argue with the judge when he's rendering a verdict.
Well, I think he did the only thing he could do on the at-law side, which was, he can't see equity on the at-law side. So he's the one judge that holds to both sides, but it's up to you to invoke the right side. Might have been on his wrong foot in the at-law to start off with, and never could be switched back on the right track.
Right.
I had high hopes that the motion to dismiss would have been a transferal, but we need to be doing maybe a little more research into that to make sure that a motion to dismiss and how to make sure it's a transferal instead of a dismissal.
Well, that's interesting because the attorney for the ADFNA and the trustee, the standing 13 trustee, both put in motions for dismissal.
Yeah, but they didn't put anything. It's probably, if it's a bill in equity, which is the counterclaim, it's up to you to put in a motion to dismiss, and then make sure that it acts as a transfer, that it should be transferred from the at-law side to the at-law docket to the equity docket.
So, am I hearing you correctly that whenever you put in a counterclaim, you must put in a motion for dismissal and have it
yeah, because this motion to dismiss is going to be colorable. It's going to be a dismissal, and in fact, it's going to dismiss the at-law side for a lack of equity rights. They failed to state a claim upon which relief can be granted because equitable relief can be granted. They failed to state a claim upon which an equitable relief can be granted because there is no equity in their at-law side. Dismiss that, which transfer from the at-law side to the equity docket. Because there is no adequate remedy at law on the exclusive jurisdiction of a breach of trust is executed in equity. And that gives you the better equity or the superior equity claim.
Okay.
So equity obtains jurisdiction where the remedy at law was not plain, adequate, and complete. And I've probably used this too, ... And if the remedy at law failed in some essential quality, and the aid of equity might be invoked.
So use that verbiage in your motion for dismissal?
Yeah. So equity obtains jurisdiction where the remedy at law was not plain, adequate, and complete. Well, they don't have an equitable right that they're claiming at law at all, let alone they could see it. So, therefore, the at law side falls down, and it's held in its essential quality. And now the aid of equity can come in and be invoked. So the motion to dismiss, based on plaintiff failed to state an equitable claim upon which relief can be granted, transfer to the equity docket.
Okay.
I invoke the equity side of the court, transfer to the equity docket. And then if I had my pleading special matters in the bill, and it was in negative averment form, and I had the elements for the breach, or for the proving of the trust, and I asked for a declaratory relief hearing as a summons in personam, and a ducis tecum, for the discovery, say, or the counting, and come in for the proof of the validity of the trust at that hearing.
Okay. So the only person that would need to be summoned, the subpoena, would be the trustee, right? The standing 13 trustee.
Whoever the trustee was on your trust.
That would be the standing trustee, 13 trustee.
Okay, so they're both trustee of the bankruptcy, and they're also trustee on your trust.
Right.
Okay. Mm-hmm.
Which might or might not have been a good idea, but it worked out.
And ask for the equitable relief. You want the performance on a breach of the trust. You want an accounting. You want a tracing on the proceeds therefrom. And you want a receiver appointed to do the trade.
Now, would that all be put in the bill in equity, all of that?
Yeah, because that's your relief one.
Okay, yep, gotcha. Well,
So that would be the relief under the performance for the breach of the trust. That would be your mandatory injunction.
well, if we put in this motion for the dismissal of the bankruptcy, could that motion be withdrawn if we need the bankruptcy to stay there?
Yeah, you could always withdraw it.
Okay.
Motion to withdraw whatever your motion was.
It was a motion to withdraw from the bankruptcy.
Motion to withdraw the withdrawal from the bankruptcy.
Exactly.
Actually, if you could get into the equity side, you could put a stay on the bankruptcy side to do the liquidation 7, because that's the at-law side.
Right.
And then also enjoin all the other parties that's associated with it that they're stayed also.
Well, would that mean that the state would have to reopen the business?
No, but they wouldn't proceed anything other what they're doing. They can't. It's like they're stuck frozen. That's it. They can't proceed. They can't regress. They're frozen. They can't do an enforcement until after this is done.
So the business would have to stay closed until everything was settled.
Correct.
And in the meantime, everybody starting to death.
Start a new business. Except this time, don't be a business. Every customer that walks in your door, have them sign a private agreement that they're operating in the private. That way, you're not doing business and any income can't be associated with a business or trade in the United States.
Not public. So could you do that, set up your cash register, your receipt, and have them sign all the receipts?
Yeah, they'd have to sign an agreement that they're operating strictly in the private.
Each time they did business, or?
Once they've signed up, they don't have to sign another one. So.
Okay.
That
might be the thing to do.
You'd have to have a database of class of people that belong to your trust, and that's what you're doing. You're getting them in a trust, private trust. And you're operating in the private. And it's not considered business or trade, and it's not taxable because it's not in the United States.
Right. So, could you charge them $1 for the membership to the trust organization?
Yeah, some kind of valuable consideration. But you want to give them in a confidential agreement. Excuse me. So that you're relying on that.
So that would be one way. That'd be a way of getting around doing business in the public, then, correct?
Yes, that's people need to start thinking how to operate in the public or in the private. I mean.
What about your vendors? Would you have to have an agreement with them as well? Okay. Well, that's definitely something for food for thought. How to get around this public stuff.
I mean, thinking like they do. How come they can get you in a private confidential trust and you didn't even know about it? Well, they used the application for the Social Security, the 1040 forms, the birth certificate application. They used all these things, and you didn't know what you were getting into. Get them in a confidential relationship, and the proceeds that you're granting, which would be, say, the meal. And it's reliance on that there needs to be returned to you sometime in the future.
And that would be a payment.
Mm-hmm.
Would you be under for example, you have to be inspected by the county and all that stuff? If you're doing a private thing, will they still come and do their thing?
I don't think so, because it's not. It's private. You got to put something private on your door. You can't enter unless you're a member. It's a private
establishment.
You're trespassing. Public's out. This is not a public establishment.
Yeah. But would they, before they did business with you, would you have to have them sign an agreement before you sold them the mill or something, or could that be part of the? How would you, especially if you have new clients coming in?
So the new clients would have to sign some kind of a confidential agreement. Make up some kind of card that they have, a membership card, and they got to have the card to order.
Yeah. definitely good thought.
Yeah, we need to think outside the box because that's where we operate.
Well, now, if the license has been returned, that trust has been terminated.
Well, no, it has not been terminated until you terminate it. You filled out the application. Now, I would merge the application with, and terminate the two titles. Terminate that whole thing.
Well, that process was done. It was the
done?
license was
All right.
signed and returned, and they were making the claim that the business was operating without a license.
Well, that was true. 100% true.
Well, it does in the case if we call private. Could we have taken the business private at that point?
Well, it was private. They just didn't make that distinction.
So we should rebut it when they say that. Say, hey, well, this is a private business now. It's not public.
It might be that with the termination order, you should probably give I was going to say, well, kind of like an expungement of the record.
Could he not file suit against the state and say, hey, you closed a private business?
Well, if they're looking at it still as they can still see it, and they're still bothering you, it's because they haven't really closed the private side, or they really haven't terminated the private side of the ledger. They really haven't terminated the account, and then that's the problem.
Even though they've had a termination
order, yeah, they're in breach because they haven't terminated it. They've been given the order, but they haven't terminated it. Because if they terminate it, now they can't see you, and they got to leave you alone. But see, you set it in motion by putting it in as the general, and now you got to get it switched from general to special. And the only way you're going to do that is to get them in the breach of trust and get into equity first, and force them to do that, which you can't get into equity, and you're kind of like a stop because you can't get into equity.
Right. And there's no money flow now from the business because they've got the doors closed.
Yeah, it's like this train has been set on a path under the general train track, and you're not on the right train track. You're going to nowhere land. And you got to get it switched from on that track, that general track, to on the special track, going the opposite direction back to where you came from.
Well, would it not be prudent to go ahead and let that train crash into the canyon and go and start another business, only do it in private?
Well, I know that creates a mess, and then they got to clean the mess up, and then they got to bill you for it.
Well,
under the general, what you did was you created an imbalance, and now they got to balance the books because you didn't balance the books, and they do that by putting a bond and coming in and arresting you. And all this is commercial because that's what the general side is, all commercial.
Right.
Somehow you give the equity, and you got to get this reverse from the general to special in equity because equity is going to look through for the real substance, which is your intent, and you have an intent to change this from general to special because it was a mistake to begin with.
Right.
And a mistake is also a heightened pleading, which is also under pleading special matters, and that has to be a negative averment also. So, but just for your information.
Right. Sounds like the negative averment's rather important there.
I think so, because if it's not negative averment, then it looks like the negative averment is the special, and the straight averment is the outlaw side.
Oh, okay. That's the distinction.
Mm-hmm.
Okay.
Negative averment in expression of the breach of trust in equity.
On such and such a day, you received the indenture and special orders. Signed for them.
Yeah, everything pled in breach of the performance, breach of the trust, has got to.
Yep.
And everything else is in positive averment. Like your other stuff. I'm not talking about the.
Okay.
Anything else?
No, I think that does it. It's always very enlightening to chat with you. Shame you don't live next door.
I'm just a Skype away. Okay, if that's it, we'll go on to somebody else then.
Breach trust. If they go ahead and dismiss the adversarial claim with the bankruptcy, then should we go ahead and just file a new case in federal court against her for breach of trust?
I think I'd try the state courts because it's a little bit easier there, I think. And then if you didn't go there, win there, you could go up to, say, federal.
Well, a while ago when you guys were talking about knowing whether the court is an equitable court or not, it kind of has been our experience when you call and ask those kind of questions. Well, we asked the judge, and the judge said it was, but he didn't, in that particular court, he didn't behave as though it were in equity. Well, twice. Judge did the court. Do you know anything about the concept of if the judge leaves the courtroom in the middle of court and has a recess, that when he comes back, he's changed the law form or the venue?
Yeah, I've heard that before. It'd be a trial de novo, over again, so I might have to do the same thing again. But that's why it's important.
Well, we noticed that in my case when the judge was had a demeanor of one type of demeanor. She called a recess, left the courtroom for 10 or 15 minutes, and came back, and she was a snake, and had a completely different language and a different demeanor, and it was obvious something was different.
Mm-hmm.
So our understanding is that went from commercial court into maritime, admiralty maritime, and that is that not the court of the sea? The SEE?
Rule C.
Rule C.
Supplemental Rules of Admiralty. Rule C.
Okay. Well, she did it twice. We may be in Talmudic law now. I'm not sure. Now, can we go ahead and put an objection file an objection to the case to object to the fact that she has changed law forms?
Yeah, you could, but where's your SOI proof to back that up?
Well, it would be superficial. She was meaner than snake. Yelling contempt charges everywhere.
Well, it's probably because you picked up the snake and you dropped it and it got away. You need to pick up the snake and put it in the bag. Now you got it under trust.
Yeah, exactly. Well, that's my attempt anyway. Well, we already started talking about trust when she really got all upset and left. Yeah, that's when she left the courtroom, when we started discussing trust. She came back to matters and meaner than a wet worm and left again.
How'd you try picking up again on the same venue or?
Well, I don't remember now exactly how much you got to get a lawyer. Yeah, that's when she came in and said I had to get a lawyer.
Your Honor, you didn't answer my first question when you left.
Yeah.
What is your answer on the first question before you left? We can't proceed.
We didn't
answer my question.
Yeah, we didn't get an answer on that trust. Well, we were supposed to have had a telephonic hearing to determine whether whether I was going to accept the lawyer or not. Well, they called me 15 minutes late or 30 minutes late on the day of the hearing for the
Yeah, well, it's like when you ask a question, you got to get an answer and take them to the 3-strike rule and get them in a dishonor. Get them in a breach. Get them in a breach of the trust. Right off the bat.
Okay.
And also, if the judge wants to be an SOB, let him be one, but I'll recuse you. First one's freebie. I can throw the judge right off the bench just because I don't like his hair. Let's get a new judge in here and we'll try again if you want to act like an SOB. The next time I'm going to disqualify you. Recuse him first time, freebie, and next time I'll disqualify you.
That's when they're not behaving like a judge is supposed to behave?
Right. Well, no. Disqualification is different from recusal. Recusal, you got the freebie from the first, and the judge is supposed to jump off himself. The disqualification now goes up to the judge's panel, and he must, it's a different procedure, and it involves the higher-ups.
Right.
Anyway, for the breach of the trust and going to 3 strikes, and then it's like, okay, you may come out screaming and yelling and acting like a 900-pound gorilla, but you're not the 900-pound gorilla. You didn't answer my first question. Now, for the second time on it for the record, what's the answer to that one? For the third time on it for the record, what is the answer to that? First one was fault and then default and dishonor. Now you have this court's in dishonor. I want to know, you're recused. Get out of here. I want to know who's going to hear this matter.
Yeah. Yeah, they seem to be able to intimidate.
Yeah, that's their big stick.
Not interested.
When I asked a question, I want an answer to my question.
She was asking a lot of questions. If I understand yours, dictionary, the judge is not supposed to ask any questions unless the evidence has been put into the case. Is that correct?
Well, Your Honor, do you have first-hand knowledge on that? Are you testifying for the plaintiff? If you are, you're operating outside your scope of authority, and now you're going to subject your bond to personal indemnity. If I choose, I can go commercial remedy, and I can terminate it all. And I can go after the proceeds that you attached on the backs of all this crap. Go after the bid bond, performance bond, and the payment bond, track down the QSIP numbers on this bankruptcy, and find out, where all these funds are, and then terminate them all. Pocketbook, where they don't have any funds to operate on these big numbers that they're accustomed to getting with all these accounts and all the different levels, then maybe they would start acting a little bit more respect.
So, say you have claim title or all rights title and interest to that case. How do you go about claiming those bonds and performance bonds, bid bonds, and payment bonds?
Well, an equitable relief for an accounting, because I want to trace the proceeds from my trust res.
Okay, so that's part of your relief request.
Yes.
And you put it in by tracking you're asking for an accounting and tracking of all the bonds and all the proceeds.
Yeah, I want to trace the QSIP numbers of the bid bond, performance bond, and payment bond that were generated from this case.
Okay.
Because they are my proceeds under trust. I want to be appointed over this to track them, to trace them. I want a constructive trust put in place because they're holding my assets falsely. They've stolen them. That's what the breach of trust is. Trustee has absconded with the funds. He's breached the trust.
Yep.
I want to know where the proceeds are. I want them traced. I want a special receiver put up to do the tracing.
Mm-hmm. Well, that was one of the things that the trustee of the 13 standing trustee on the trust, it was expressed, she made the statement that there were no funds in the trust.
According to her, she might not know that there is any funds in the trust, but maybe instead of appointing that party as a trustee because they're the lowest ones in the total poll, maybe should have gone upstairs to the district trustee and made them trustee, or somebody in the head of the division or something higher up.
Would it be prudent to go ahead and maybe appoint another co-trustee?
Well, one might be doing the same thing as the last one did, so what good would it do?
Yeah, they probably continue repudiating.
And then where's all this being sent to? It's like, okay, are we attacking it at both ends? So we got it on, say, the microcosm end, but how about on the macrocosm end, the other end of the stick?
Are we covering all of it?
Yeah, well, I'm thinking IRS.
Uh-huh.
I mean, they're the real accountants. They're the ones that take care of the accounts, and they're the ones that the trustee should be going to. But if they don't know to go to the IRS, then I guess you got to go there.
So would that be done with the Form 3849 or what it is?
Well, I'm not so sure. I want to use the IRS forms anymore. It's like the W-8 Ben, but you got to use a W-8 Ben substitute, which they say is not their form. It's because you're making up the form. But it contains the essential stuff that they need to accomplish what it accomplishes.
Yeah.
I really think that maybe some of these forms to the IRS and stuff are nothing more than just, the private side of the corporation side, which is corporations all rely in the public venue anyway. So it's all the private side of the public venue, which is not the real true private side.
Right.
The look-alike again. And it may have to
match
all the forms for doing what you need to do is they all have to be modified like the W-8 Ben substitute. But I think I think it was Albert that said that the IRS is aware of withdrawal and redeposit. It's alive and well.
So yeah, I heard him talking about that the other night. How would you apply that rest of trust on, say, the Allison Dune? And because I have done this, and I'm still getting this notice from them that I still owe them money. So do I just continue sending the note or the?
There's one thing that I have never mentioned on any show, and I really can't release it yet because it's in the documents that we got coming up, and it could be the key that makes all this work.
Well, Christmas was last week. Anyway, I'm just going to merge the title and send it back to the CFO, and then send a note to.
All right, here's the it's on a state level compared to a federal level. Although they're acting as one, but they're like the opposite ends of a stick, and they're functioning as two models of themselves. So what's the same on one end is the same on the other end, except they're just one's positive, say one's negative. So if you come at the federal IRS and expect them to do something, there is a state equivalent.
So if you send a merged title to the IRS federal...
You're coming in on the IRS private side, but you're not coming in on the state equivalent on the private side. And you got to have both ends of the stick because it's one stick.
So you need to get the CFO or whatever of the state taxing board or whatever they want to call it.
You've got to find the private side of the state, which is the equivalent to the federal, which is the IRS.
And are they going to be willing to divulge that information, or are you going to have to? Is there an office? I'm wondering, how do you find out what the private side of the state is?
That's the trick. How do you join this private realm? You know, it's like, okay, you know, how do you gain the knowledge?
Is that kind of like chapel at the court?
Kind of like what?
The chapel at the court.
Chapel at the court.
The door to the chapel of the court is down by the broom closet.
Yeah.
On the bottom floor of the
almost
courthouse.
Everything in this world today that's happening is done in a duality, which is really trust because that's segregation. That's two sides of the coin. Coin is consisting of two sides, and we don't think in duality. And you must have control of both sides or the duality simultaneously, or you can't get accomplished what you're trying to accomplish. And none of us think that way. That is a real trick, and believe me, that's a little hard to start out with. To get
Well, not trained to think
private, and to say that you've got to juggle these balls both on public and private simultaneously is a little hard. But it's like riding a bike. After a while, it becomes second nature. But just like we know that there's a public side to the IRS and there's a private side to the IRS, so on the state equivalent, which is the opposite end of the stick, is there a private side to the state and a public side to the state? State Treasury.
So if you're dealing with an IRS issue and you're looking for the private side of the state, what exactly are you going to send to the state on the private side that would be the opposite end of the federal of the IRS?
To the federal, which was your orders to terminate and extinguish.
So you send an indenture that you sent to the CFO of the IRS to an indenture or the same indenture to the CFO of the private side of the state?
You've created the documents, you've merged the title, you terminated the account, so to speak, and now you just got to send it to the accountant, and he gets to ledger it.
Oh, okay. No, with the state treasurer.
Now we're expecting the trustee to ledger it, and the trustee, he ain't got the ledgers. He doesn't know where the ledgers are.
Okay.
And the IRS is the ledger on the federal, and the state's got its equivalent. And they both work hand.
Well, that's I'm sure there are a lot of people who are excited about hearing that bit of information.
Well, I've kind of mentioned it before. Everybody wants to go and they're pursue the court thing, but then I don't think they're coming back and letting the IRS know, hey, you know, what you've done.
I might have to think about the state part.
Look at
We normally don't think
books and
state
older pre-33 books and find out where it's talking about the equitable conversion. I think I posted it in the NTT group the other day. The equitable conversion is what they're doing with your signature. That's how they're converting your signature into an asset by conversion, equitable conversion.
Right.
Then who's the people who keep track of that? The ledgers or the accountants?
Now, if you called the state office, would they tell you who the accountant is, or maybe the head accountant of the state tax board or whatever?
It's just like what we had to do. We had to search around till we found out where the private side of the Treasury really was. You know, not all the U.S. Treasury IRS is the same. You know, some's the front door, the public side, and the other one's the back door, the private side. And what we want to do continuously is we want to do back office banking, if there is such a thing. We want to do the back office transactions. They're all special. They're special handling.
Speaking of doing back office banking,
I think the banking part of it is no, because we're really not doing banking. Banking's on the public side. We want to do private side
trust.
Yeah.
Is it necessary to get the number via the SS4 form to be able to do your trust banking, for lack of a better word?
Well, the name and the number is just a way of surveying and identifying it. It's the ID, which is the essential thing. We have identification.
Am I understanding correctly that you have to have this number in order to open up a special account, i.e. trust account?
Oh, no, you don't. No, like a Taunton trust? No, I think if you use the W-8 Ben substitute form, you could probably open it up without a Social Security number.
Oh, okay. Good name. Well, I appreciate it, Christian. We might ought to hush up and let someone else talk.
Okay, all right.
Thank you.
Thanks, Don.
We certainly covered some interesting ground.
Yeah, we did tonight, yeah.
Hey, Christian, for everybody, I'm going to post a link for the Equity on Jurisprudence, or a treatise on equity jurisprudence by Pomeroy on the Welcome NTT chat.
In reference to what?
Equitable conversion.
Oh, okay.
And it's going to be page 126 of the book, everyone. So it's going to be up over page 200 of the PDF. I don't know exactly what it is, but I know it's page 126.
All right.
And Mike from Chicago was saying last week about, how do we prove that the signature is our equitable asset? Right there it is.
Conversion.
Yeah, now you got to read between the lines. This is talking about real estate and estates and things, but just read between the lines.
So they've kind of obscured it.
Yeah, it's there. You can see how they're doing it. They can they'll change real estate into a personal, and they'll change personal into real estate.
Well, now, real estate also means the estate of, doesn't it? The estate?
Yeah, it's really real. Or I don't know.
It's a play on words.
I did a show on the states probably back in 5 something this year.
Yeah.
This year.
What show, Christian?
Oh, well, I talked about estates.
Oh, estates. Oh, 424.
424.
Yeah, and it was back in the spring.
That determines your status, your tenure. Okay, we got some other people in line, so.
Thank you.
All right, Dan and Doyle, thanks.
Hello?
Oh.
Hi, Christian. It's Jeff from California. How are you? Can you hear me? Hello?
Yes, I can hear you.
Okay, great. Well, a couple of interesting things. When you were bringing up that concept of private agreement to be able to do business with a private agreement, but now what would you use for consideration? I mean, are you still dealing in public money, Federal Reserve notes?
To form a trust, is any consideration necessary?
So even if you have a private agreement or a private trust, essentially, and you could still be using Federal Reserve notes and still that be considered private?
The uniqueness of a trust is that to form a trust, there is no consideration necessary.
Oh. Just intent, purpose, and parties.
The uniqueness
and res.
of the trust. No consideration is necessary to form a trust. So there wasn't consideration given to form this trust. If there was no consideration given, then how can you be taxed?
But what if they are giving you consideration in the form of Federal Reserve notes?
You can't be given consideration.
Okay.
Trust. Think trust, people. As much as we've gone over this stuff, you still don't get it.
Well,
who has the right to take?
The beneficiary.
Take what?
His beneficial interest.
What's that?
That would be his value, the perceived equitable interest, perceived equitable value.
What's
the unlimited value?
What's that?
The interest.
What's that? The rent, the fee, the use.
Use, yeah.
Tax.
Tax.
Does that make sense?
Yeah.
What are they getting from you?
Exactly that.
Why? Because it's under misconstruement that they have the right to take.
Right.
And what's that mean?
That means they're acting as a beneficiary and you're acting as a
right. Now, get yourself in a position where you get to take from the trustee what rents and fees he collects for the use of what you granted him. You people do not think. You can't think any farther than your noses. And we're all pathetic. And we deserve the government that we've got because none of us think. We don't use the brains God gave us. We want to go play. We want to watch TV. We don't want to learn nothing. We don't want to apply anything. We don't want to think. We want somebody else to do it for us. Well, we got the kind of government that we deserve because the government is doing it for us. Because we don't think.
I think the challenge, Christian, is separating the public and the private. I think it's really the public policy. For me, when I think private, I don't
pick you out. I'm not picking you out. We must learn to live this because it is your life. You've got to eat, sleep, and drink trust. You've got to apply NTT process night and day.
Yeah.
It is your life. Otherwise, you're nothing but a slave. You got to free your mind. There's a difference between knowing the path and walking the path. There's a difference between knowing NTT and doing NTT. It all stems from the foundation. I can see this stuff as plain as day. Can you? Because I'll tell you, night and day, I live this stuff. You must also.
I understand that.
I'm trying to get everybody up to speed, and everybody is missing the mark. By now, you ought to be teachers. But it all comes back down to the basics of, the trust. The trustee is got the legal title, and he can do a lease, and he's gathering rents from the lease, which is the use of the property. But he owes a duty back to the beneficiary. So everything that he gets for the use or the rent or the fee or the tax is due back to the beneficiary. Get yourself in beneficiary position out of court. So you can get the rents and the fees. Got to get in the position where you got the right to take. Power is in the choice, and the force comes in equity. And I am equity. We are equity.
Yeah, I understand that.
We are the.
Pretty much.
But first, you got to make the choice, the right choice, and that's general and special. And everything you do every day is evolving choices, whether it's general or special. What is the relationship you're forming? Because that's the key on a moment-by-moment basis, especially when you're signing your name. Only the beneficiary has the right to take. Why are they taking from us? They're either taking because they're trustees and they're not giving it to the beneficiaries, or else they consider themselves to be beneficiaries and us to be trustees, and they're taking from us. I don't care which way you want to look at it. Both of them are the misconceptions of wrong thinking.
Well, I always assumed that they were just playing creditor debtor, and they're taking because they're assuming they're the creditor and we're the debtor.
Well, I think they're all playing trust on the private side, and they're confusing us. We're playing the debtor-creditor.
Oh, I see. Yeah.
They're enforcing the trust, and they're taking under trust. And you're the ones thinking it's debtor-creditor.
Yeah.
By our failure to repudiate.
Well, isn't their general offer a creditor-debtor relationship? Wouldn't that be what their offer for general deposit is coming in under the creditor-debtor relationship?
Who had the choice? The offer doesn't count. It's the choice.
Okay.
That you make.
Yeah. Well, it's your intent, like you say, the relationship. Once they make the offer, then how you deal with that, withdraw that general deposit, make it a special deposit, and realign the relationship.
Yeah, and most everybody makes the general deposit, which forms the debtor-creditor relation by default automatically.
Yeah.
Everywhere, all over the place.
Sure.
Moment by moment, as Christian said.
Yeah.
Now we need to stop forming our businesses in the public. Keep them private. Stop giving them general deposits in the bank. Make them trusts. Make everything a trust. Start thinking trust 24 hours a day. Start thinking the two titles, legal and beneficial, and their relation and how they interwork with one another. Put it up on a whiteboard. Go down to Office Home Depot for $10. Get an 8x10, 8 or 4x8 sheet whiteboard and hang it up on your wall. And get some marking pens and diagram all this stuff out. Start thinking multiple titles. Everybody's confused on one title, legal title, and they're being led as a nose ring around in life because of a legal title. Because you want possession. I don't want possession. I don't want possession of nothing. I want to be in control of everything, having the right to take from everybody else that's got possession, because I gave them possession. Because I granted it to them as grantor. Most powerful thing that you got in knowledge is knowing that you are the grantor of everything. And until you come to that conclusion and the understanding of that, you will be lost in life. Not in control of your life. You'll be like a ping pong ball bouncing off the walls going down the hallway. And that's not the shortest distance between 2 points. That's a straight line. None of us are walking a straight line path. All about trust and the understanding of a private trust enforceable in equity and what equity is all about. And eventually we'll get into equity. You can bet your bottom on that. Anything else, Jeff?
No, when you brought up jurisdiction in the beginning, Black's Eighth, they have a term of equity jurisdiction in there. Did you read that?
Black's Eighth on equity jurisdiction?
Yeah, they had it under jurisdiction. I can read it if you'd like.
Yeah, go ahead.
Okay, so it has a couple paragraphs here. Equity jurisdiction. In a common law judicial system, the power to hear certain civil actions according to the procedure of the Court of Chancery and to resolve them according to equitable rules. So that one basically goes C cases equity, federal courts, CJS equity. And then it goes on for another paragraph. The term equity jurisdiction does not refer to jurisdiction in the sense of the power conferred by the sovereign on the court over specified subject matters, or to jurisdiction over the res or the persons of the parties in a particular proceeding, but refers rather to the merits. The want of equity jurisdiction does not mean that the court has no power to act, but that it should not act as on the ground, for example, that there is an adequate remedy at law. And they cite Handbook of Modern Equity, William D. Funick.
Which Black's edition are you reading from?
That was from the 8th, Black 8th.
Yeah, no,
Under
I've
jurisdiction.
some discrepancies with that, or with what was said in the 8th there. When it talks about the merits, equity doesn't have to do anything with merits.
So they're talking about
do with substance.
That's what I thought. So they're talking about statutory equity then.
Right.
So they're just trying to throw us off track.
Yeah,
I was kind of curious.
Focused on the subject matter, which would be the res, instead of the relationship, which is purely substantive and a right.
So that's essentially what they did to equity. They basically made people focus on the merits instead of the actual substance and res.
Yeah, because it's the focus is a relationship. A trust is a relationship. Equity is about a relationship, in the exclusive jurisdiction of equity. Trust. And trust is a relationship between real live beings.
Right.
Not about any kind of substance, any kind of facts, any kind of res. It's about a relationship.
Relations, yeah.
Because that relation between me and the trustee is he's got a duty that he owes me, and I've got the right to take from him. That's our relationship. And in regards to the res, whatever it is, but the res is secondary. But they want you to get the focus on the res, being the merits. No, it's not about that. It's about the relationship.
Yeah. Who's got the right to take?
Yeah, that's it. It boils down just to that. And we got that knowledge back from the beginning when we started with Lewin's book and really started getting into the trust back in 11/7 of 2009. And we learned it from the grassroots up instead of from the top down.
Who has the right to take has the right to charge the fee.
Yes, whoever the grantor is, set it up. And it's per his intent.
Okay, a couple other things. One of the TAs I was talking to brought up an interesting point. He's like, well, if it's privileges and benefits, the benefits would mean we have a beneficial interest, which is kind of an interesting point. I hadn't really thought about it like that. I was just like, well, maybe it's all just privileges, and then they just basically they consider everything that they.
Yeah, but who's granting the privilege?
Right.
Them or you?
Well, that's in the public. They assume they're granting the privilege, I think.
If the grant comes from the public, then it would be a privilege. If the grant comes from a real live man, then it would be something different. It wouldn't be a privilege; it'd be a right.
Right.
But the relation is key, and that's general versus special. And it's the understanding or the discernment to figure out why the A through Z garbage out there, how it works.
Yeah.
Or how to make sense of all the confusion methods out there. It's all in the relation to the estate, and the estate being a trust, or collateral being the survey, which is the witness. It's the identity. And the identity consists of A, the name, the B, the boundary, and C, whether it's public versus private, one of the two. It's a relation of trust in the use of the res by the trustee in exchange for the beneficiary's fee, which is the performance of the duty, the right to take, the fee simple, held in trust. And anyone else that takes has mistaken the res, the fee, in repudiation of the trustee's duty to the beneficiary. That's all it is. So ponder about that over the next month.
Okay, sounds good.
Hey, Christian, one of the things that we never brought out is the definition of general. All this time, I don't know that we've ever actually read it on the calls. Is there if I share it?
Yeah, go ahead. Mm-hmm.
All right, it's out of Black's Fourth. General, and it's from the Latin word genus. It relates to the whole kind, class, or order, and pertaining to or distinguishing from distinguishing the genus or class as distinguished from that which characterizes the species or individual, universal, not particularized as opposed to special, principal or central as opposed to local, open or available to all as opposed to select, obtaining commonly or recognized universally as opposed to particular, universal or unbounded as opposed to limited, comprehending the whole as directed to the whole, as distinguished from anything applying to or designed for a portion only.
It's the nature and character.
Yes.
Whether it's general, or whether it's a general nature and character, or whether it's a special nature and character.
And we have many things that are many entries in Black's Law that are followed by general, and the term general estate is one of them, and it says customarily the entire estate held by a person in his individual capacity.
Now there's a general estate and there's a special estate, and they both exist at the same time, simultaneously.
Just what the one we choose to claim and have the evidence to support.
General estate being public, the special estate being private.
And when you were talking to Jeff and you were talking about the privilege and the benefit, and I was thinking about when the beneficiary exercises their right to take and brings a suit for it, is that in effect a tax due upon the trustee?
Yeah, you ever look up the definition of tax?
Well, I was about to, just to share that with everybody.
Poll. The deed poll. That's an indenture. We're talking about trust, which comes back down to right to take again.
You said tax is poll?
Yeah, poll tax.
Poll, P-O-L-L. And what's the definition of poll?
An indenture. A deed poll.
Hey, Christian?
Yeah.
Doesn't the trustee also receive a fee for administrating the trust?
No, that's in CJS. It says the trustee is not entitled to a fee, although he can get a fee, or they can grant him a fee.
Oh, the grantor can grant him a fee, but he cannot take a fee. He cannot.
That's indenture.
I got it. Okay. So the trustee really just has all the legal duties, and he really doesn't get any fee, unless the grantor decides to grant him a fee, or the beneficiary gives him a fee.
Right.
Can I share the definition of deed poll?
That's a serration split in half that the two halves match.
Is what a deed poll is?
Mm-hmm.
Okay. I'll share it out of Black Sports, and then we'll liken it to what you said. You said it's a serration, it's split in half. Okay. And deed poll says a deed which is made by one party only, a deed in which only the party making it executes it or binds himself to it by it as a deed. It was originally so called because the edge of the paper or parchment was polled or cut in a straight line wherein it was distinguished from a deed, indented, or indenture. As to a special use of this term from Pennsylvania colonial times, see Heron v. Dater.
Remember, a deed is an act.
Uh-huh.
An act written down by words on a piece of paper. What was the act? Oh, I did a sale to so-and-so.
So that's why when we go back to tax, what we were talking about a minute ago, that's why the IRS is so effective at collecting what they collect, because they're simply exercising their beneficial rights by our general deposit.
Yeah, it's also through the Tribune, the Roman Tribune. You paid tribute.
So because we're paying tribute, and because they're taking their tribute by beneficial right, until we change the nature of the relation, we really don't have any prayer of being successful.
Absolutely nothing.
Because we signed up for the duty. When the patriot idiots get crazy about some of the stuff that they read in the U.S. Code and the CFR about what they can use to fight against the IRS, now just in the simple idea that the IRS is there to simply collect their tax, that they know they have the right to take by our own deposit by signing a 1040 as a trustee.
Yeah, the general deposit makes you a free man. You get a fee simple. You are the churl. And if the churl contumaciously neglected to render his services or rent, it would seem that he could expect no mercy. George Spence, Equitable Jurisdiction on the Court of Chancery, 1845, Volume 1, Chapter 11, page 49, paragraph 2.
And I bet you're not even looking at that right now, are you?
Well, yes, I am, but...
Okay.
It's the time of the Norman Conquest, and that's when all this came about, 1066. The land throughout the kingdom generally was cultivated by persons attached to the soil. Of the same were in absolute slavery. Others, under the name of churls, were treated as free men. The churls are mentioned in the earliest of the codes, and they had their cottages and slaves or laborers. In other words, they were just a higher form of slaves, really. The churls were attached to the soil in which they were recognized interest, Generally speaking, so long as the churl paid his accustomed rent and performed his accustomed services, whether general or defined, neither he nor his children could be removed from the land. Doesn't that sound like today? Nor by law could a higher rent or a greater proportion of labor be extracted from him than custom warranted. But if the churl contumaciously neglected, in other words, he'd be under contempt of the court, neglected to render his services or rent, it would seem that he could expect no mercy.
And when we take that model and we apply it to what's going on today, being a general depositor, and they keep on passing more bills in the legislature, they just find more and more ways to have no mercy on us from with their right to take.
Yeah, but the law is nothing without equity, and equity is everything, even without the law. And those who perceive what is just and what is unjust only through the eyes of law never see it as well as those who behold it with the eyes of equity. Law may be looked upon in the same manner as an assistance for those who have weak perception of wrong and right, in the same way that optical glasses are used for those who are short-sighted, or those whose visual organs are deficient. Equity, in its true and genuine meaning, is the soul and spirit of the law. Positive law is construed, and rational law is made by it. John Bouvier, Institutes of American Law, 1882, Volume 2, Section 3724, Paragraph 4.
And to take that wonderful, magical power of equity and apply it would stop these blood-hungry people in office that just continue to spend more through their beneficial right to take with our general deposit. So we could stop being enslaved as churls. We could utilize equity and continue to, and begin to extinguish so much of what these guys have racked up against us.
Yeah, the scriptures say that the law was written on your heart. But what law was written on your heart? It wasn't the Ten Commandments. It was equity. It was the eyes of equity, the perception of right and wrong. And we need to put those glasses back on and correct our short-sighted because our visual organs had become deficient. And now we could see equity for what it really is. It's the source, it is the spirit, and it is the soul of the law. In other words, the law, as being the statutes and codes or the common law or whatever law it was, its source is equity. It is the God-conscious mind. And I said it before, NTT, I'm not so much excited about NTT as NTT being a road leading me to a God consciousness through the equitable maxims which are the interface to understanding a God mind. With that, I don't need 63 million laws. I can see the law for what it really is. I can discern it's right or it's wrong just by looking at it. The law is nothing without equity, and equity is everything, even without law. Frame that. Put it above your computer. Anything else?
Well, if you have other callers, I don't want to get in the way.
It's getting late. Getting ready to close it down. So.
All right.
Am I still on, Christian?
Yeah. Mm-hmm.
I have one other question, or just kind of an idea, just something small, but the trust res, when you're sending trust res and you're kind of wanting to go after the bid bond, performance bond, payment bond, do you think it would be a smart idea, or is this totally crazy, to get those GSA forms, the bid bond, payment bond, performance bond, find the CUSIP number, put those in as trust res, put a identifying claim number on them, and turn that in with the res?
No. If it's got a QSIP number, that becomes the title to it. And all I need is a title to merge it with the equitable asset side, and I terminate it. And that's all I'm interested in finding out because I want to terminate this.
Right.
I'm not going to use it. I'm not going to spend it. I'm not going to treat it as commerce and do business with it. I'm going to terminate it.
Terminate them. You want to get rid of the debt.
I want to get rid of the debt because that is the millstone around everybody's neck.
Yeah, that's what's killing everybody. It
might not solve my immediate problem. You know, maybe I might starve out in the street, but I'm better off if I terminate that debt because in the long run, I'm going to win.
He who claims equity must do equity. It's kind of the greatest good. Just exterminate the debt, extinguish the debt.
Yeah, the debt is out of hand. It's the millstone drowning us all. How long can we keep on swimming with this millstone around our neck?
Yeah, I think it's because the right to take from the public, these public officials, has gotten out of control. They're not in check. We have not been able to put them in check. We've failed our duty, so they just keep taking. They keep taking and growing the debt because we're not doing our part to stop it.
Yeah, you've given them absolute power, and now absolute power totally corrupts. Absolutely.
Absolutely, yeah. There is no other way for them because they've already misconstrued the relationship, so it's already alien from the beginning. So they're just going to keep the corruption. I mean, they have no other choice. It started out corrupt. You cannot get a
need commerce to exist.
Yeah.
You do not need commerce. None of it. I don't need Caesar's coin.
Well,
there was an full existence for Adam and Eve prior to the fall.
Right. But Cain slew Abel. So Cain to me represented commerce and Abel was equity.
And we don't need it.
Yeah.
Okay, is that it?
Yeah, that's it. Thank you so much. Have a great night.
Hey, Chris, will you announce TalkShoe's phone number and PIN code?
TalkShoe's PIN number?
Yeah, because I don't know if I heard you say it in a while. If we got newbies on the call that want to come on Wednesday.
All right, it's 724-444-7444. That's TalkShoe's number, and the PIN number is 41875 pound 1 pound.
And that's at 8 p.m. Eastern.
8 p.m.
Tomorrow night.
Okay, is that it? That's it?
That's it.
Okay. Night all. See you tomorrow. 8 o'clock. TalkShoe. Think Trust.